David Davis.
Thank you, Madam Deputy Speaker. It's a particular pleasure to follow my old sparring partner from East Yorkshire on this as much as any other issue. In order that, since we've only got a very short time, I'm going to focus on one issue alone out of, I think, the four that really affect this bill. When this government brought a different but related bill before the House, the so-called Snoopers Charter, it was, frankly, an embarrassment. It was pilloried by the Joint Committee on the Draft Communications Bill and heavily criticised by both MPs and Lords. And one clear fact that arose out of that review was that many thought that RIPA, the bill upon which this legislation is based, was simply not fit for purpose, was too loose, and if the Snoopers Charter came before the House at some later stage, many would use it to rewrite RIPA. Certainly many Liberals thought that, and a number of Conservatives too, and some members of other parties. Now, that may be one reason why the government is uncomfortable about giving this a full procedure over several weeks with proper committee stage and report stage and so on, because it may find that it gets a tighter definition of RIPA than it previously had. Now, the House knows I am not a great fan of the British government being told what to do by the European Court of Justice or indeed the European Court of Human Rights. I much prefer that British liberties, our freedom, our privacy are protected by Parliament. But the harsh truth is that Parliament has been a weak defender of our freedoms this past 20 years, and this process we are facing today, crashing this bill through the Commons in a single day, even more poignantly, I see the empty benches around me on reshuffle day, is an awful demonstration of that. And one consequence, of course, of that slack attitude is that we have bumped more and more frequently into treaty obligations and to international court judgments against us, where Britain should be the shining example, not the villain of the peace. And this bill does nothing to correct that. Now, the court, as a number of speakers have mentioned, branded the untargeted mass collection of our data, this is European rather than just ours, as wide-ranging and particularly serious interference with our fundamental rights. Now, it's arguably the case that Britain is the most extreme example of that in some ways across Western Europe. And because the bill does nothing to correct that particular aspect, it is, in my view, likely to face legal challenge and may well fail as a result, which will not be beneficial to security in this country if that happens. And much of this failure hinges on the fact that access to communication data in this country is not subject to judicial approval. It's one of the differences between ourselves and America and some other European countries. It's approved by officers of the same organisation that request it. Now, the result of that, and this is, I think, the point that the Honourable Lady from Brighton was referring to, is that too many people have too much access too easily to too much data. That's really the core point. And we use this power in that respect, therefore, more often than many of our international colleagues. Now, to take the numbers, there were 514,000 approvals for authorisations and notices reported in the RIPA 2013 report. By comparison, it's very difficult to compare countries, but to give a partial comparison, yes, I will, just very briefly. Yep.
I'm helping him, he'll get an extra minute. I thought I heard the right honourable gentleman say that those who authorised communication data requests are the same people as those who checked it. I think the right honourable gentleman will find that's not correct. There's a system of surveillance commissioners who are there to do the authorisation, and the checking is done separately.
Correct, I'm afraid. The authorisation process does not go to the commissioners. It comes back afterwards to the commissioners. Now, but the point about this anyway is the numbers, and that is this, that the Americans who we compare with, who we can partially compare with, only use 38,000 to 57,000 references in a given year. And in Europe, perhaps the most, the country that perhaps least admires the privacy of its own nationals is France, and its total metadata approvals is 35,950, 36,000. If you add in all of the other approval process, it still comes to less than half of ours. So access to our data has insufficient safeguards. There's no prior review to access by a court or by an independent body, and the after-event oversight, the Commission oversight, is incredibly under-resourced, So the intention was that data only be used, of course, for prevention, detection or criminal prosecution of offences that may be considered sufficiently serious to justify such an interference. Well, serious crimes. There are 100,000 indictable offences which may face custodial sentences in the UK each year. 100,000, those are those numbers. About 80,000 indictable go to actually end up in prison. We're talking about 500-odd thousand approvals to actually deal with less than 100,000 prosecutions. Now, the last point I want to make is the government seeks to diminish the importance and sensitivity of communication data by distinguishing it from the content of the communications. Now, at one time, this firm distinction actually stood up, was credible. But now, because of technology, rather than going the other way of actually making things more difficult for the agencies, the scale of modern internet and mobile phone technology has actually provided an intimate picture of people's personal lives. And in the ECJ's words, this data, taken as a whole, may provide very precise information on the private lives of the persons whose data are retained, such as habits of everyday life, permanent or temporary place of residence, daily or other movements, activities carried out, social relationships and social environments frequented. In other words, it's an incredibly intrusive piece of information. Now, as I said, I don't like taking lessons from the European Court of Justice, but I'm afraid in this they are absolutely correct. These measures are just not proportionate. They were badly designed in 2000, I'm sorry to say, to the member for Blackburn, and they got worse with the passage of time and technology. The government has not listened and accordingly has left itself open, I think, to legal challenge. So while this may be law by the end of the week, it may be junk by the end of the year.
Keith Baird.